Preferred Capital Funding presents the Result Podcast, a podcast where trial lawyers share a recent verdict or settlement and discuss how they achieved the result. The Result Podcast is brought to you by Preferred Capital Funding. PCF provides loans to your clients, all while providing the highest level of customer service and continuing to be 100% attorney referral based. If you have a client in need of a loan, please contact me at jason@pcfcash.com. Now let's hear from attorney Sydney McClafferty of Geiser, Bowman & McClafferty in Columbus, Ohio, about how PCF has been able to serve her and her clients.
My clients have greatly appreciated having an attorney who has the resources to meet their needs quickly. PCF is a fast and accessible resource for my clients, allowing me to provide solutions to their most urgent concerns, whether that be funding for continuation of health insurance or money to replace a car so they can return to work. It's truly been a lifesaver for some.
Today, the Result Podcast is happy to welcome Jason Abraham of Hupy & Abraham. Headquartered in Milwaukee, Wisconsin, Hupy & Abraham also has locations throughout Wisconsin, Illinois, and Iowa. Jason handles personal injury matters across the country, having resolved over $350 million in case value. He's a member of numerous organizations, including the Multi-Million-Dollar Advocates Forum and the Wisconsin Association for Justice, where he has served as a board member since 1993. Jason, welcome to the podcast.
Thanks so much for having me. I'm excited to be here.
Well, as with all of our episodes, we like to start at the end. Can you tell us what the monetary result of the case we'll be discussing today is?
$3 million.
Walk us through the case.
Yeah, it's a police brutality case, and it's interesting because obviously these are the kind of cases that are back in the media and news almost daily now with our current state of events. But going back to actually 2003, we had a client by the name of Curtis Harris who was rendered a quadriplegic in a booking room in the Milwaukee Police Department. Ultimately, we resolved the case, as I said, for $3 million in October of 2009, just before the federal jury trial was going to begin. And it was dealing with this case that I first really understood and realized, how much of this police brutality stuff happens and how it gets covered up. And it was just really interesting going back that long ago, to have a case of this magnitude at the time, and it still may be. It was the biggest police brutality settlement in Wisconsin history, and just to see how it played out, and then bring us to today's date where we see these things commonplace now, and just understanding how hard these cases are to work up, how hard they were back then, and the hurdles we had, and it's just crazy to think now that these kind of things are in the forefront of our minds today. So, that's the case I wanted to bring to us today.
Can you walk us through what happened to your client?
Yeah, Curtis was living with his sister, and the sister had a no drinking policy at her house, and he was drinking, and she was upset about it, so she called the police. The police came, and in the beginning, they just started roughing him up. They punched him in the face. They threw him down to the ground as they handcuffed him and brought him down from the second level of the house to outside to bring him into the police car. They were grabbing and let go of his handcuffs, creating a permanent scarring into his wrists with the handcuffs. And then when they got him downstairs, before they put him into the police car, they asked him if he liked mud, and then they pushed him down in the mud, and there was this just general discourse and treating him really poorly when none of that needed to be happening at the time. I mean, the only thing they were arresting him for there was disorderly conduct, because in the privacy of his sister's home, he'd been drinking. So he was drunk at the time, and when he got into the locked booking room, he was belligerent and really upset about how he was treated. Well, I think this bad Apple police officer got tired of it in the booking room, and as they were walking him up to the desk in the booking room, he pushed my client from behind, and my client turned, and then the police officer grabbed him and threw him headfirst into a cement wall, rendering him a quadriplegic in the booking room. And from the moment he was thrown into the wall, obviously, and had his spinal cord severed, the police at that time made a joke of it. They were laughing at him when he said when he finally came to, about a minute into the incident, he was saying he couldn't feel his arm and his legs, and kind of moaning, and then going in and out of consciousness. And they were laughing at him. They actually didn't even call the paramedics right away. They tried to pick him up and put him in a chair. Obviously, he fell right out of the chair. It was probably 2 or 3 minutes into the incident, as he was laying there, that they finally realized that they may have a problem. And then they called the ambulance to come. And when the minute that they came into the locked booking room where he was, because there ended up being a videotape with audio, the first thing they said to the responding ambulance people was that he was trying to win an Academy Award. Well, ultimately, he needed surgery to stop him from dying that day, and then ultimately was paralyzed for the rest of his life as a result of what happened in the booking room.
Jason, how do you approach a case like this when it comes to your firm?
Well, I mean, back then, the climate for bringing a case against police was much different than it is today. So what you have to do is just investigate the hell out of it to see what happened. We were told early that there may be a videotape of the incident. We made an open records request, and we were told by the city attorney's office that there, in fact, was no video. We then filed back up with Internal Affairs, who was investigating what had happened to Curtis in the booking room. And they said to us, no, there in fact is a videotape. And at that point, I realized in my mind that if there was no videotape, there probably was no case. If you go back to 2003 and just bringing my own sense of police into what was happening, I think everyone had a sense of, and this was probably true, 99% of all the do a great job, care about what's happening, care about treating people with respect, and there always is the bad apple. I think today's climate, even though that's still probably true, there isn't so much of a leaning towards back then that the police do everything right and by the book, and this wouldn't happen, and so you just have to investigate it, and thankfully we ultimately got the videotape, and it showed exactly what our client said had happened, which was he didn't do anything. The officers, after this had happened and they realized how serious it was, started to cover up, and everything that transpired from there was saying that my client tried to throw a punch, and this was necessary conduct on behalf of the officers. And so it's just a matter of understanding that when you take on a big case, you have to plan for it to be tried from the beginning. If you don't plan on being able to try the case, you're never going to be able to do the job necessary to get the client what the client is entitled to.
What would you say was the most interesting aspect of the discovery process? And tell us what experts, if any, you used in this case.
Yeah, we used plenty of experts. We had former police officers. We had officers that train other officers in the schools before they even become police officers. We had day in the life experts, medical experts, future medical life care planning experts. So there was a lot being put into the case. I think the thing that stands out in my mind in the case were two really interesting things. Early on, this videotape, trying to make sure that we could get that before that got destroyed, because as I said earlier, without that, there probably was no case. And then number two, just trying to figure out who this officer was. To do something like this, we knew we had a bad apple. And the question was, how bad did the apple get? And one of the most interesting things that happened in the case is this officer, mid-case, all of a sudden was injured on duty. And the story that came out was that this officer was taken by a defendant, stuffed in the trunk of a car, and then taken on a chase while on duty by the defendant criminal, and suffered some serious injuries on duty. And then all of a sudden on the news, this officer's in the hospital getting accommodations from the mayor. And, where we thought this guy, we were going to have a fairly easy time proving that he was a bad apple, all of a sudden there was all this good press for this officer. And then within about 6 months of the trial, all of a sudden another officer came out and said that, no, that's not what happened. What was going on was that there were a bunch of police officers that were sledding in the winter on duty, and that this officer was on his sled on duty and actually hit a tree after he was sledding and became seriously injured. And rather than coming clean and saying what had happened, he lied about what had happened and came up with this whole grandiose story to try to get this accommodation and look good in the press and not get fired. And so then we had this huge battle on our hands to determine whether or not we could bring all that into the trial, because he clearly was a liar, and to show to the jury, this is the kind of character of the person that did this to Curtis Harris. And shortly before the trial, the federal court judge ruled that all that could come in. And I think that was the final straw that allowed the case to get settled. Up until that point, the city of Milwaukee offered no more than $500,000 on the case. And then, as I said, on the eve of the trial, the case got settled for $3 million.
How did the defense approach the case from the other side? I always think in these, it's really interesting to see how adamant they are or are not in their approach.
It was such a different time. I mean, I think back then everyone would believe, for the most part, that there were no bad apples back there. So the city attorney's approach was more or less Curtis had it coming. And even though there was the videotape that, in my mind, with 100% certainty showed Curtis Harris never tried to punch the police officer, that was their claim throughout, even with videotape evidence that our client threw a punch, our client was the initiator, and this officer did nothing wrong. They got the other two officers in the booking room to also lie and say that our client threw a punch. And I think when I look back on it, I think one of the biggest mistakes they made was that in the process. The city attorney didn't have the officers look at the videotape before they were deposed. And so what they said clearly wasn't on the videotape. I think that was a huge mistake. She thought it would be to her benefit to not have them see the videotape. And so, they were then locked in with stories that just contradicted, the video. And so I think their approach was more or less, we're going to go up and prejudice this plaintiff. He's in jail, and we're going to say he's a bad guy and the cops are good guys. And as a result, we're going to win, because if you go back to 2003, or when the case is going to be tried in 2009, I think the general consensus was these kind of things just don't happen. And that just isn't the way it is anymore.
True. I know that we're talking about the civil side, but were any sanctions brought against the officer for the incident?
No, there wasn't, actually. It was all covered up. And when we went back and looked at when Internal Affairs presented everything was presented in a way to make it seem like Curtis Harris tried to punch the officer first, and then this was reasonable force that was used after that. So there was really a cover up from the beginning, even though Internal Affairs did us a real solid by telling us about the videotape. Everything was presented back then in a way to try to not have anything happen to the officer. But he was ultimately fired anyways, because he concocted that whole bizarre story when he was sledding. And so he ended up losing his job before the trial as a result of that whole lie and scandal.
It always catches up with you at some point.
It does. It sure does.
What was your demand going in?
Oh boy, I don't think we ever got to a demand until we started right before the trial, because I think at one point our demand was $5 million to their $500,000. And then, right now, if you think about a $3 million settlement in 2020 for something like this, it may not sound like a ton when your client's a quadriplegic, but, back then in 2009, where there were not a lot of successful cases brought against police, we had gotten a settlement at that point that could change Curtis Harris's life going forward, could make a huge difference at that point. And when we had that obtained for him, it would have almost been impossible to keep going, because he needed that money to have a quality of life going forward as a person that was paralyzed. And you just couldn't take the gamble based on the climate. If I had his case today, it would just be a totally different case.
Well, let's talk about that a little bit, because I think that's very interesting that you were successful in a case in a time that would be astronomically more difficult than what it would be present day. A lot of our listenership are other fellow trial attorneys. If you were to have this same case today, knowing what you know from the 2003 case, what would you do differently? What do you think is integral to success in this style of case?
The interesting part is I wouldn't do anything differently. It's just a totally different climate where people are now more accustomed to videotape evidence, seeing things go wrong with rogue police officers. And believe me, I'm not someone that's going to stand up here and say that 20% of the police officers are bad. I don't think that there are any worse amount of bad acting officers today than there were back in 2003. I just think it's a different climate where people have cell phones, people tape things, you see things. And I think people are believe things that they understand that this stuff happens now. I mean, it's been getting to a point recently where every day on the news you're seeing another something where there's a videotape of something like this happening to a citizen. And I think if you go back to 2003, this was so uncommon that you'd be able to get a successful case like this. And it just was not the norm. That I wouldn't do anything differently. I prepare my cases the same today as I did then. You prepare them for trial, you dot the I's, you cross the T's. You have to expect the cases to go to trial. You have to spend the money. I think if there's one thing I say to people that do what we do, I think there's a hesitation to spend the money because let's say 98% of your cases ultimately settle anyway. So therefore, why do I spend all this money on experts? Why do I do all that? Well, you do that to show the party on the other stand that you're serious, that in the event the case has to be tried, you're willing to do that. And so although I wouldn't necessarily do anything differently, the public perception is so different that my case from 2003 today, I would say would be worth at least $10 million. And the fear of losing the case would be so much smaller. Like I just would feel like, and not that any cases can't be lost because they all can be lost, but you would just look at it and say, I think there'd be a 90% chance of winning than maybe a 40% chance of winning. And that goes a long way in determining how much money you're willing to take. But still, the analysis is the same. If I can get a settlement for a client that can change my client's life, you are running a real gamble, and it's not your case, it's the client's case. And I think that's another thing I've learned over time. I've represented myself personally, over 1,000 people myself. My office has represented over 70,000 people, and we've got well over $1 billion for injured people. And one thing I have not lost sight of is that these aren't our cases; they're our clients' cases. And we suffer if we lose our costs, we lose a fee, but we have plenty of other cases to back that up. And we need to be humble enough to understand that these cases aren't ours; they're the clients. And if we have a good settlement, and although we may think it's worth more money, if we've reached the goals of the client, and on these big cases, if we can to change their life in a way that makes it for the better, we need to be humble enough to understand these cases can be lost. We've all lost cases we thought we were going to for sure win. I've had 7-figure offers on a case and lost. But if there's one thing I always do, I make sure that the client's making the decision. I educate them, because we have to be smart enough to realize that no one case can't be lost, and not lose sight of whose case it is and the goals.
I think that is sage advice. Jason, is there anything today that we missed that you'd like to go over before we wrap this up?
No, I'm just grateful that you guys have given me the opportunity to talk about a case that was important to me. I still think about my client today, and I think it's important out there to just let people know about doing good work and hard work and taking care of people in today's society.
Well, congratulations on a great result. Really appreciate you taking the time to be on the podcast.
Thank you.